To the CSBARS meeting, and I know that we have some people who are in the audience, as well as those of us here from the committee, as well as members of the State Bar staff. It is a day that is a culmination of a lot of work over the last year. And before we get started with roll call, which I'm going to ask Grant to take, I do want to acknowledge that there is going to be a new name in our roll call, and I want to acknowledge that Paul Kramer is joining CSBARS, and Kareem Gangora is cycling off. Kareem hopefully is in the audience right now and is able to hear me, but if not, I'll make sure to pass a note to him. I just want to thank Kareem for his really thoughtful contributions, the way that he listened with curiosity and really a lot of humbleness to the experience of the deans as we talked through some of these issues. And I really want to acknowledge and thank him for his steady focus on diversity, equity, and inclusion issues. And he always tried to orient us back to those questions as we worked our way through this new set of rules. So while I am very sorry to see Kareem go, because I thought he added an incredible amount to our discussions, we're losing Kareem, but we are also gaining an incredible CBE member in Paul Kramer. For all of you who attend the CBE meetings on a regular basis, you know that Paul is always prepared for every CBE meeting, no matter how big that agenda is. He asks difficult but really important questions, and he takes the CBE's mission very, and keeps it as a high point as gatekeeper, and he keeps that as a focus. So I want to welcome Paul to CSBARS because I think he's going to add a lot to what we do here going forward. So Paul, welcome.
Thank you.
And Grant, you can go ahead and take the role now that we know that there's a new name in there and why we lost one.
All right, so let's start. Dean Jackie Gardina.
Here.
Dean Greg Brandis. No. Dean. Oh, sorry, what?
Greg is here.
Yeah, yes, I'm here.
Okay, perfect.
Sorry, may not have worked.
Dean J. Frickberg.
Present.
Paul Kramer.
Present.
Mr. Greg Murphy. Greg Murphy. Dean Martin Pritikin.
Here.
And Dean Brian Pertil.
Here.
All right, we have a quorum.
All right, thank you very much, Grant. So next up is an approval of the August 2020 minutes, and I'm going to do that before we get to the comment period because there is some changes to the agenda I want to address. So has everyone had the opportunity to review the minutes from August? Okay, is there a motion? Great.
Actually, Jackie, I have a very minor correction to the minutes. So this is proposed for section E, the very last sentence of section E, wherein the minutes describe the conversation around the rules proposal at the last meeting, and state something like to the effect that the deans presented a number of comments for alternatives which will be presented to the committee. And so I would like to add the words "some of which will be shared with the committee," because in fact that's how it turned out. Only a handful of the conversation and comments of the deans in the previous 4 hours spent on those rules actually came up at the committee meeting. So it would be inaccurate to say that they were shared. It would be accurate to say that some of them were shared.
All right. Just have a motion and then we can have discussion on the proposed amendment.
So I move to approve the minutes with that amendment.
With that correction. Okay, is there any discussion on that? All right, do I have a second?
I'll second it.
All right, all right. So all those in favor of moving the minutes with the correction identified by Greg Brandis and seconded by Brian Pertel.
Now, because we are on a on a recorded line rather than in person, we'll need to do a roll call.
So should I begin roll call?
Yes, please.
All right. Dean Jackie Gardina,
Yes.
Dean Greg Brandis,
Yes.
Dean Jay Frickberg,
Aye.
Paul Kramer,
Yes.
Mr. Greg Murphy, Dean Martin Pritikin,
Yes.
and Dean Brian Pertil.
Yes.
The motion passes.
Thank you,
And
Grant.
as a point of clarification, though Paul Kramer was not on the CSBARS at that time, he both attended the meeting and watched the playback, and therefore has elected to vote as to minutes.
Thank you, Natalie. So just want to address some changes to the agenda, just a rearrangement of the agenda because of some other state bar matters that are being attended to. As you may know, the provisional licensing committee is meeting at 2 p.m. today. Both Paul Kramer and Amy Nunez will need to leave the meeting, this meeting, in order to go and attend that. So we're going to have Amy do a presentation on the staff report number 5, the Blue Ribbon Commission on the future of the bar examination, and then an update on the 2020 a report on the provisional licensing program. So numbers 4 and number 5 we're going to do now. We're then going to shift directly to the rules so that Paul is here for that discussion as long as he can be. Both Kareem and I believe Michael Cow, who worked diligently with Paul on the rules, is in the audience, so they'll be able to take back any discussion points that perhaps Paul is not here for. So I wanted to allow public comment as it relates to number 4, the provisional licensing program, and an update on the Blue Ribbon Commission on the future of the bar examination after we hear the update from Amy. So Amy, please, if you could provide the update, and then we'll open it up for public comment on both those.
Absolutely. Hi, everyone. So I'll start with the provisional licensing program. As many of you are aware, in July of this year, the California Supreme Court directed the State Bar to develop and implement a temporary supervised provisional licensure program. So it's a limited license to practice California under the practice California law under the supervision of a licensed attorney. So provisional licensure working group was established to help design the parameters of the program. And the working group developed a proposal which also included a 15-day comment period that ended on September 15th. That proposal was approved by the board at their September 24th meeting. And basically the proposed rules allow for provisional licensure of 2020 law graduates who meet all eligibility requirements for admission to the state bar, with the exception of a few. One is sitting for and passing the California bar exam. Secondly, having a final positive moral character determination, and also having passed the multi-state professional responsibility exam, the MPRE. The purpose of the PLP was to respond to those law school graduates who had little to no opportunity to take the bar exam prior to the pandemic due to the recency of their graduation from law school. The proposed program requires supervision by a California licensed attorney, but provides significant discretion to the supervising lawyer to determine the degree of supervision required for the provisionally licensed lawyer based on their demonstrated knowledge, skills, and abilities. On September 18th, the working group met, before reporting to the BOT, and they discussed the various public comments that were received. Among them was a concern expressed by the public that the program was limited to recent graduates. Again, it's graduates between December 2019 and December 2020. At that meeting, the idea of expanding eligibility was introduced, and that's what will be discussed today. So again, today the working group is meeting again to discuss a consideration that some consideration be given to bar exam applicants that scored at least a 1390, which is the new bar exam passing score on previous bar examinations. So the group will also be discussing whether such applicants should be permitted admission to the state bar without taking another bar exam upon successful completion of a set number of supervised hours under the PLP program. So should that be the case, the working group can then revise the proposed rules that are being submitted to the California Supreme Court for adoption. And again, that's going to be part of the discussion today. And the goal is to implement this program no later than December 2020. And one correction I want to make that I've reported last time is that the program is good through June 2022. Sorry, let me drink some water.
Glass of water. Okay. So Amy, rest your throat for a moment. Any questions from the commission that we can entertain while Amy rests her throat on the PLP? Paul?
Yeah, Amy, as I understand it, the rules that the working group did adopt were forwarded to the Supreme Court and would be considered by them, could be considered by them this month, correct?
Yes. So any decisions today would be a revision to those rules.
Okay. All right. Any other questions from the committee right now? All right. Amy, I'm going to have you do the Blue Ribbon Commission as well, and then we'll have the public comment on both those items.
All right. So some of this may be repetitive because I've talked about the Blue Ribbon Commission. The state board at its May 14th meeting approved establishing this joint Blue Ribbon Commission on the future of the California bar exam. So it's a partnership with the California Supreme Court and the state bar. That commission will be charged to consider the California Practice Analysis Working Group report and recommendations. So this is the CAPA job analysis, as well as the results of the National Conference of Bar Examiners 2020 job analysis. The commission will also be charged with assessing whether there's sufficient alignment between the California and national job analysis and any national plan to change to the uniform bar examination to consider adopting the UBE. So also to develop recommendations to the court and the state bar regarding revisions to the California bar exam should, if the UBE is not recommended for adoption. The commission is going to consist of 16 members appointed by the California Supreme Court. They're going to represent key institutional entities, various attorney practice sectors and settings, and should reflect the state's demographic and geographic diversity. At least 2 of the members shall have been admitted to practice law in California within 3 years from the date of their appointment. The commission will also be staffed by state bar staff and include liaisons from the Supreme Court, and may also include liaisons from the legislature. Next week, the Supreme Court will be meeting to discuss this item, and once approved, a formal solicitation process for members will commence. At the last meeting, I talked about the fact that this discussion was scheduled to take place in September. That did not happen. It's happening next week. And so the idea is for us to then formally submit an announcement for solicitations as soon as that happens.
Thank you, Amy. Any questions from the committee? And then we'll open it up for public comment on both those items. No? Okay. All right. I welcome any public comment on either the Blue Ribbon or question regarding the Blue Ribbon Commission or the report on the provisional licensing program.
Question, how long should we provide each question?
Thank you, Grant. So 2 minutes for public comment.
2 minutes, yeah.
Thank you. Okay, seeing no public comment on these issues, what we want to do now is pivot to the rules so that Paul Kramer, who's been intimately involved with them at the CBE level, can hear both the comments from the committee as well as any public comments that might come forth. And he's also here to describe the process as well as the substantive work that was done at the committee level. So just a reminder for those who are listening in who may not have been aware of the process that took place in our August meeting, and the CBE took it up originally in their August CBE meeting. There was a set of CSBARS proposed rules, a set of staff rules, and an identification of where they diverged. The CBE had that on their agenda in August. They, I think, wisely chose to table it. The CSBARS members had not had the opportunity to fully absorb the staff recommendations and understand their implications. And the CBE hadn't had that same opportunity as well. So they tabled it, taking it up again in October. During that time between August and the meeting that will be held on Friday, 2 CBE members really took on the bulk of the work related to understanding the CSBARS and the staff proposals. And that was Paul Kramer and Michael Cow, who hopefully is in the audience, and I welcome his input when the time is right. I asked Paul to describe, not right now the substantive work that was done, but just the process that was done internally so that both the committee members as well as the public could understand what happened between August and this point with that set of rules. So Paul, I'd invite you to describe the work that you and Michael did along with the State Bar staff.
Okay, thanks. My background was as a regulatory attorney for the state of California, and one of the things I did quite frequently was to draft or, in many cases, review draft regulations that were prepared by staff at the agencies I worked. And so when I saw these rules, I couldn't put my editor's hat in the closet and just read them for what they were. I saw a room to improve them, and mindful that you don't get this opportunity too often. Because these rules have to go through a process that's beyond the Committee of Bar Examiners in some cases, probably not in this one, but in some cases all the way to the Supreme Court. I wanted to take the opportunity to make them as good as they could be from a rules drafting standpoint while I had the chance. I'll just give you one example. The whole concept of it was called deemed approved schools, which we've now changed the name to jointly accredited. That was in the draft that I saw. It was expressed in basically a section that was about the scope of the rules themselves. And organizationally, I thought that deserved its own chapter in the rules because it was a very important concept. If you will, it's a third kind of law school: provisionally accredited, fully accredited, and then jointly accredited. So many of the changes I made were along those lines, and cleaning up some duplication in the definitions. That was my interest. I'm also interested, and I've been working with Natalie and Michael to try to lay out in a cognizable way for the members of the committee what the issues are and what the differences between the staff's position and the position of the law schools is regarding those major issues. And we even went so far as to allow Jackie and Marty to fill in the school's portion of the table we created to convey that information. So we're going to disagree about some things. I predict this, but I wanted to make sure that the committee is getting a full view of what the nature of those disagreements are and the arguments for and in advance. And before I forget, I want to mention to you, I was touching base with our new chair and vice chair earlier today, and I believe they are going to be expecting you folks to make your comments about the rules to the full committee during the public comment portion of the agenda, which occurs at the beginning of the agenda. So it may be that you are making those comments, and it may be several hours before the committee then actually gets to them. I just wanted to make sure that you understood that I believe that is going to be their approach.
Thank you, Paul, very much. And just to put the meeting with Paul and Michael in context, when Marty and I had the opportunity to meet with them, Marty and I were clear that we could not represent CSBARS, that the comments that we were making couldn't be perceived to be or represented as those that the committees would make, and that Paul should and the CBE and potentially the Board of Trustees should anticipate that other members of the committee may bring things to their attention that Marty and I may have missed or didn't put forth, or that members of the public who didn't have the opportunity to fully engage with the rules at the August meeting may bring information to the CBE and to the Board of Trustees and during the notice and public comment period that the CSBARS members didn't raise either. So although we have a set of rules, still comments to come from both within the committee as well as from members of the public. So I do want to thank Michael and Paul for the attention that they gave to Marty and I's comments, and that that they were curious and listened to what we had to say. I can say that the rearranging that Paul talked about in terms of making the rules kind of stronger in terms of form is something that you might notice that's different from the August meetings. There isn't a lot of CSBARS changes that were added back into what is the current proposal that reflects very much the staff proposal. I think Marty and I were able to successfully convince Paul and Michael that perhaps raising the limit on the internship and clinical hours was something that would be warranted. And Brian, I think in your comments, and it certainly came up in Marty and I's comments, the idea about the probationary hearing and the time frame were added back in regarding that probationary piece. But beyond that, it should look very much substantively like what we saw at the August meeting. So want to give people an opportunity. I know that both the rules and the comparison chart, so you can see the difference, are on the agenda. So if you want to bring those up at home yourself, that's great. We can also share it on the screen. The only downside to that is it does end up squishing everyone to the side, and we don't necessarily get to see everyone's faces as we're having that discussion. So members of the committee, would you like it shared on the screen, or are you more comfortable sharing it at home on your computers?
I'm fine doing it at home, and I apologize for not being on camera, but my internet connection is a little unstable, so I'm trying to preserve bandwidth. I hope you can hear me okay.
Yes, Marty, we can. Thank you. Okay, so we're going to put the comparison chart up. I do want to invite members of the public to make any comments that they have to make sure that we can incorporate those into the discussion. So Brant, would you mind not sharing the screen? We were going to, yeah, just keep it so that we can actually see each other more clearly. Are there members of the public who might like to make comments now about the rules? Okay. So I see that there's a couple of hands raised.
All right, DE, you have 2 minutes.
They're muted again.
I sent a request to unmute. DE, I believe you have to unmute yourself.
My apologies. I did not mean to raise my hand. That was them. My apologies. Thanks.
Thank you.
Michael Winnick,
Thank you. This is Dean Mitchell Winnick from Monterey College of Law. And first of all, let me thank you guys for, again, continued hard work on this. I only have two things I would like to bring up. One I feel very strongly about for your reconsideration, and that is the proposal on 4.144 that would theoretically allow inspection teams to be entirely staff and allows them to no longer require to have peer review. I think I'd remind everyone that this entire process started, I believe it was by Leah Wilson, with the idea that we would look at best practices for accreditation entities. And I suspect you will not find a single accreditation entity of any type that doesn't include peer review as part of the inspection teams. So, I mean, that one change pretty well guts the really the standards of best practices for accreditation. So I would ask that that be reconsidered. The other one is I'm a little less strenuous about, but I just have a question to talk about 12.5% of whatever that is, experiential training. First of all, we don't teach by percentage of curriculum. So that's almost an impossible standard, or at least it shows that there's no reflection that this is an academic program that teaches by units. So a 12.5%, I understand, is probably addressing the fact that there's different graduation requirements that range anywhere from 84 to 90 units. But I don't believe that really gets where you want to go. And also, I believe that that type of an arbitrary limitation of that type of training, you couldn't pick something that goes more opposite to what the bench and the bar is calling upon law schools to do, which is to expand our focus on experiential and clinical type skills training, not artificially restricted. So with those two suggestions, again, thank you for all your hard work.
Thank you.
Thank you, Mitch. I don't see any other hands raised at this point, so I do want to open it up for committees. Oh, Greg Murphy.
Thank you, and I apologize for being a few minutes late to the meeting. I got hung up on another matter. I just wanted to respond to the very thoughtful comment that was just made. The American Bar Association, the council, and the accreditation before me did participate in kind of peer review in the earlier days of the accreditation process. But since I went on the accreditation committee originally in 2002, and then through my term on the council, which ended just this year, there was a movement away from doing peer review. And the reason for that was that as the regulator of the law schools, turns out that peer review, particularly offered by members of inspection teams and like, actually ended up causing problems with the enforcement. Unintentional. It's one of those unintentional consequences. A regulator is primarily involved in assuring that the entity regulated is meeting the minimum standards that are set forth by the accrediting agency. So I understand the desire for it, for peer review, but that's probably better accomplished by a voluntary association. For most American law schools that are accredited by the ABA, that would be membership in the Association of American Law Schools. I don't know whether the unaccredited or the California accredited schools have such an association, but they might consider forming that for that very purpose of peer review.
Thank you, Greg. I know Marty would like to speak, even though we can't see him. And then Jay.
Yeah, I know Jay raised his hand as well. So I think he raised his hand before I let you know I wanted to speak. So I'm happy to defer to him first.
All right, thank you, Marty. Jay, do you want to take next?
Sure, just so we don't go back and forth, otherwise it'll never move forward. Just first a comment, then a question. A comment to Mr. Kramer. Again, thank you for the time and obvious heavy labor in going through this. I can see there's a lot of thoughtfulness as to the structure that I wasn't as focused on before, as well as the substance. So I could see, from helping to draft and work on this, I can see a lot of labor and thought went into this. For the question, is this more of a notification to us within CSBARS of this is the updated proposal for the replacement of the rules? Or are we still in a stage right now where we can have discourse and there could be comment from this going to the committee?
Well, it's being presented to the committee on Friday, the bar examiners, and it may be adopted. So unless there are some major issues that require, you know, more work than can be accomplished in the course of the meeting. But yes, but your comments are welcome. You just don't have a lot of time to submit them to make sure that they're heard before it's possible adoption. But this has been going on for, I mean, this is a long process, and we feel like we're at the conclusion of it.
No, definitely understood, but my question wasn't about me personally, but about CSBARS. So is this just a notification, this is what we're submitting and there will be no changes or alterations noticed to the bar? Because as an example, I find at least 2 drafting issues as well as 6 substantive issues that I would like to discuss. But if this is not a negotiation with CSBARS at this point, then should I just raise these issues later with the committee as a public comment versus a CSBARS comment?
Oh, I'd be glad to hear them, because if we agree that there's a drafting improvement, I would push it forward myself.
Thank you.
So what do you got?
Like I go right through them, share them. Sometimes I take up too much time by doing that, but I'm more than happy to. I'll start with the substantive ones then. Is that okay, Jackie?
Yes.
First one was already referenced, page 9. And again, I'm referencing pages and sections from the updated proposal to replace the accredited law school rules. I'm using that as the document to discuss from. Page 9, rule 4.147. Again, one discussion point on that one. As to the end of A, 4147A, last line, jointly accredited law school shall provide the state bar with timely copies of its correspondence with any other accreditor. Again, that's concerning to me because of the public records component of the bar. As an example, I work for an institution that is jointly accredited, and there's a distinction of proprietary information that we sometimes supply to our regional accreditor WASC. And whether that information became public, you know, that could have some issues with intellectual property rights. So is this just a reference to the public action letters from a regional accreditor? Or does this include the annual report? Does this include self-studies and site visits? Because that's a rather expansive bit of information if it's not going to be protected by the state bar.
Okay, that opens up a whole area of discussion. Natalie, do you want to take a comment? I understand the purpose of this being that we do need to see what's going on between you and the joint accreditor while we are not regularly inspecting you. We still have regulatory role, and in order to fulfill that, we need to know what's going on out there.
Mm-hmm. Sure, and I would certainly encourage Ken or Caroline to chime in as they see fit, but not only for the jointly accredited schools, but also for the Cal schools. They would have an interest in protecting proprietary and confidential information. So the State Bar is in fact subject to the California Public Records Act, but the State Bar does assert available defenses and has done so for both the jointly accredited schools in a new world, but for the CALs in the current world, because both types of schools, we believe, would be interested in that. And I defer to Ken if you have further information to add.
Yeah, I don't know if I can get maybe as specific as people are hoping, but we certainly have a number of available exemptions from CPRA. And so I think the issue here is that that stuff gets considered kind of on an individual basis, which is perhaps a little problematic when we're taking a higher view. But in terms of confidential information, personal information, And also there's a CPRA balancing test for overall the disclosure isn't warranted compared to the sort of risks of disclosure. So we take a really serious look at all of those, and I know it sounds like some issues similar to this we have addressed on an individual basis and had a firm legal basis to withhold documents there, but it is that ends up being a little bit case by case is I think probably the issue.
And is it your practice to let a school know when a request is being made so then they can also attempt to defend their rights?
I don't know. I can't answer that as an overall practice. I haven't encountered that myself. Others in OGC may have. There is a presumption that once a document is within the state bar, it's a public record regardless of where it came from, or has the presumption of being one, and that then the application has to be of the exemptions to the CPRA or the carve-outs to prevent the disclosure. But it does, CPRA does start with that presumption that it's a public record if it's in our hands.
So maybe the school then might want to flag information in a filing that they believe is protected so that it'll get attention.
Procedurally, yeah, I think that would be helpful, in terms of within the state bar and responding to a PRA request if something like that ever came in. Obviously, we would go thoroughly through all those documents regardless, but a flag of some kind in a header or however it might be would certainly not hurt.
Jay, why don't you go ahead and move through those so that, and then we'll pivot to Marty.
On that same one, again, this is a possible friendly amendment. If it was just changed to public correspondence, I think you would still have the same result that you want, because the type of things I believe that you'd be concerned about as an accreditor would be public documents, action letters, team reports, because that would already pre-filter out those intellectual property rights. At least that's how it works with the regional accreditation system, as an example with WASC.
Natalie, thoughts about that?
I think that it depends on the committee's preference in terms of knowing the final outcomes and giving that discretion to the regional accreditors, which they have earned to do that job, or if you feel that you need to see the internal workings, the committee would be accepting the determination of WASC, so that is a solution that could be considered.
Okay, and then we could always request more information from WASC if one of these communications made a blip on our radar.
Mm-hmm.
Thank you, Jay. Next.
Next is on mark page 10. It's rule 4160A1. And this was a new addition under, again, A1 at the bottom of the page. Location law school must be its primary administrative office and all law school campus locations. I just have concern with the all campus locations. I read the proposal reasoning, but as an example, thinking of our online accredited schools now, again, a more expansive thought than just my school, I think this would prohibit them, if they wanted to rent space in another state where their students happen to live, if they wanted to use that for their testing, if they wanted to use that like we're going through our COVID-19 situation. So having a restriction of all school campus locations in an online accredited law school world, I don't think makes sense.
Paul, do you want me to take that?
Go ahead.
Sure. Okay, so part of the thought there, open to your comments, was part of just the level of reach and the ability of the State Bar to have oversight for the types of schools that it chooses. The State Bar is well aware that law schools operate outside the state of California, but with the possibility that students may be anywhere, which is presumed, it would be challenging for the State Bar to have oversight over campuses that may be in other states or even other countries. And so this is meant to encourage the school to have its situs here for appropriate oversight.
Is that accomplished by having the primary administrative office here?
Here, I think, again, it depends on committee discretion. It becomes the challenge of overseeing something that's in another place. And perhaps Dean Pritikin might like to weigh in, because at Concord Law School, while they do not have campuses in other locations, they have what I believe they would refer to as service centers. And maybe he could describe those just a bit.
Well, so with Concord, we don't. We're part of Purdue University Global, which has other programs like a nursing program where they obviously have to have an in-person, clinical component. So they have in-person centers for that. But because we're not physically working on anyone's body as lawyers, they may disagree. We don't need to be physically in person. What Jay's talking about in terms of testing locations, like if you need to have an in-person final exam, I mean, my take is I don't consider that a campus. Right? It's just it's a testing location. It's not a permanent location where instruction occurs. So I don't know if we want to resolve what the definition of a campus is, but that wouldn't be my natural assumption that falls within it. So if you have some back-end support, if you have some physical services that exist out of state but don't constitute a campus, I would think it would be okay.
And I believe what I recall from the discussion was talking about certain schools have, for example, their online materials may be hosted in the cloud or in another state. We have schools that are that way. So those are not campuses per se, but they might have service elements in other places, and those were not intended to be seen as campuses. But I don't know that directly that thought of renting a temporary space for an exam or through an emergency was specifically considered. Or even widely done, possibly with the exception of this time period, but I'm not aware of that happening outside of the state. I'm aware of other schools that have used testing centers or libraries or various things just for the exam portion, but not of campuses.
So let me ask, what is the extent to which you feel you need the ability to have facilities out of state? Back office, it sounds like, is one. But would there be any teaching beyond testing anticipated to be conducted out of state? Except if it's remote, of course.
Again, I'm just trying to bring up the concept broadly for the CSBARS. And my personal view of the future of education is going to become more of a hybrid modality, where it will be distance learning, but then some students will choose to group together wherever they may be. And I was concerned about, I don't know the definition of a school campus and how expansive that definition might be, or how contractive that definition might be. And that was concerning to me, that if we could not aid our students by giving them spaces to study, to meet together, or to take exams, does this exclude that completely?
I think the challenge becomes the committee's perspective and choice as to if there is a problem. So let's say it's a practice that's done on a regular basis, but it's not done in a way that applicants are identified properly or things like that. It would be challenging for the state bar to be able to investigate if that need be. But I just don't know that it was contemplated on a temporary basis. Or that is happening very often. Remember that these rules, when they go forward, whether looking like this or in another way, will be a living document. And as conditions change, it's possible for the rules to be updated as well.
Okay, well, your comment is noted.
Thank you. So I'll move on to the next one. Mark page 14, rule 4.160B6, Bravo 6. Sorry, D, Delta 6. I'm looking at the last line of D. Quote, the student must pass the examination before any credit can be awarded. Again, this is an issue I've raised previously multiple times. It is my understanding, again, admissions from the committee can correct me, but that a student must have received credit to qualify for the first year law student exam, aka the baby bar. But according to this, the student must pass the examination before any credit can be awarded. So it appears to be a catch-22 within the rules to me.
We can check with eligibility to make sure that that's phrased properly to reflect the concept that the student does not have permission to proceed and claim credit for that year, whether at that school or another. Until that point, that's what's intended there.
And I believe that the previous incarnations of these rules, again, come from the non-accredited distance learning, where they would have credit for their first year, but they could not earn credit after the first year unless they passed within the first 3 opportunities. But I don't believe that's what it's saying, at least as I'm reading it. I'll move on to the next one.
Noted.
Marked page 15, 1-5, it's rule 4.160, B as in Bravo, 12, C as in Charlie, credit. This one I had some great difficulty with, credit hour, because there are changes added to this one. I think this is more, again, the languaging. This is coming from the Carnegie Hour, which was originally built for retirement packages for professors. And I would definitely reference to anyone that's interested in this, there are CFRs on point federally, as well as WASC has a published credit hour policy in this area that, again, has been well thought through. I think that we can achieve what the goal is here, but as an example, the language, 15 hours of verifiable academic engagement and a total of 45 hours of engagement. So there's that non-academic engagement. Normally the language I would expect here would be, we have direct faculty instruction, right? Direct faculty instruction, and then out of class work. I think if we substitute that, normally the requirement would be for every hour of direct faculty instruction, we should have 2 hours of out of class work, which would then in total give us 3 hours per hour to give us our 15 hours times 15 classes and get to our 45.
Jay, can I just jump in and address that quickly?
Absolutely.
So this issue, this isn't new from what the staff or committee just did. This language was adopted several years ago when they were trying to change the rules to allow for online learning. Because the problem was, it used to speak in terms of hours of classroom instruction. And the problem, of course, was that doesn't work for an online school. So that's why we agreed on verified academic engagement. And then there's a definition of what counts as verified academic engagement for remote learning. So this was actually sort of a carefully negotiated language that's kind of been there for a while.
Okay, so as long as it's purposeful then.
Took about 8 years to get there.
Understanding. I'm sorry, say again?
It took about 8 years to get there. I was
Well,
on all those committees.
I'll try not to
So-
unwind it in 10 seconds then.
So Jay, are you deferring to 8 years of work?
I would always defer to 8 years of careful thought versus my quick thought of reviewing these documents before a meeting. So yes, I would defer that one.
I would
Thank you.
note that as a practical matter, the wording is inclusive though. So it will encompass both the 8 years of work and Dean Frickberg's intended plan.
I'm just glad we're not all in the same room because I think Greg may have leapt across the table.
There's no question about it, Jackie. It's not even a question.
I retract that entire comment then.
So noted.
Now I have 5 versus 6 substantive areas instead. So I'll just drop that one completely. It's gone. The next one is marked page 18. Marked page 18. It's rule 4.160, D as in Delta 3. D as in Delta 3. And this was a concerning one towards the end of note 3. The committee reserves the right to require a law school to submit an audited financial statement for an independent certified public accountant. The only concern I had on that one, there was a lot of discourse and discussion about equity, inclusion, the diversity of law schools in the Cal system, and not many could afford this. So I understand the language reserves the right, but again, that's concerning that the assertion of that right might bankrupt one of the smaller Cals that might only have 30 or 40 students.
Is that all 6, Jay?
No, the last one.
Okay. Yeah.
Yeah, the last one. It's a 2-part on the last one. Mark page 20. Mark page 20. Rule 4.162 is an alpha. at the top of 20. And again, this one was already brought up by Dean Winnick. And again, two portions to this under A. It's the may versus should. Again, I think it is critical if we want to have evolution of teaching, if we want to have evolution of pedagogy, the practice of law, that there is peer review. And I thought we had a carve out that was a fair one for all parties, that it should include the following peers when possible. So if it's not possible, if there's a reason that you cannot, there's no one that wants to volunteer for it, or everyone that volunteers for it is objected to. But I think that if we can involve the peer evaluation, I've been on site visit teams for the State Bar and for WASC. I have taken more from those site visit teams than I have given in volunteering my labor for them. And I think it causes a change with those that visit, as well as the institution itself, an exchange of ideas. And if it's a may, then that may not happen. And I think this is critical. Again, if we want to be an accreditor of schools in California that are more cutting edge versus just consumer protection. So that would be my first one. Second one is under B of that same rule. And there's under C, C is in Charlie. There was a removal of the phrase of commendations and recommendations. So in our original draft version, the report would include commendations and then recommendations. And this is something I think we've lost recently within the bar from site visits. Site visits historically 10 years ago would have peer presence from a dean from another school, and it would include commentary of what was doing well, as well as what needs to change, commendations, recommendations. And it's not unique to what the bar was, because this is exactly what WASC does as well within their, again, action letters for a regional accreditor. I think this is critical because, again, transparency. These are public documents. I know I read the letters for other law schools, and I'm sure other law schools read the letters about my school. And we learn from each other in this process. And I think it's good not just to learn what is wrong and what not to do, but again, what are best practices? What is working? Can we cross-pollinate and allow that to come into our other institutions? And that has been lost just by the deletion of that phrase. So those are the last two substantive areas for me. Thank you.
Thank you, Jay. I appreciate your attention to the document. I am sensitive to the fact that both Amy and Paul will need to drop off at 2, so I want to make sure that Marty and anyone else on the committee who wants to have Paul here for the comments has the opportunity to speak. So Marty?
Yeah, I mean, I don't know if I'll be able to get through all of mine, let alone anyone else talk. I mean, if we can't get through it, should we just be submitting written comments to who? To Natalie?
So there's going to be, the CBE meeting on Friday will be an opportunity to provide public comment. As I understand it, you can correct me if I'm wrong, if they are passed, the recommendation then goes to the Board of Trustees. There'll then be an opportunity, obviously, to speak to the Board of Trustees when it's on their agenda. The Board of Trustees will then send it out for notice and public comment. And so there'd be an opportunity for us to address any lingering issues there as well. So I think, Natalie, for the CBE meeting, so that the members at least know and understand those differences, I assume those should come to you as quickly as possible, both from CSBARS members as well as members of the public. Is that accurate?
Yes, thank you. That would be greatly appreciated.
Well, in terms of public comment at the CBE meeting or the Board of Trustees meeting, I mean, we're gonna be limited to 2 minutes each, right?
That's where the written word is so much more valuable.
Yeah. I mean,
especially if it comes in advance of the meeting.
Yeah, so there's no way we'd be able to do that. Well, let me just try and address a couple of things which I think are most important. Wait, Greg, you have a?
Yeah, I just have a point of order clarification, Jackie. I think, Marty, you're assuming that the discussion of the rules has to end in 6 minutes. I mean, the meeting is scheduled for another whole hour, right? So
correct.
Special rules can continue.
Correct.
It's just get as much in that Paul needs to hear.
Paul,
right?
correct. Yes.
Okay.
No. Yeah. And
Well,
Michael Cow, who's a CBE member, is in the audience right now, and he worked closely with Paul.
Yeah, and I'm going to try to stick around for a few minutes. Amy, are you there?
Yes, I'm here.
Could you can go off right away, And if you can shoot me an email when the meeting really gets going, that I think then I can spend a few more minutes here. Because on state bar time, things never really get going right away. I think that's in Wikipedia. So I think I can give you a few more minutes.
Sure, I will shoot you an email.
All right, thank you, Paul. So Marty?
Yeah, okay, so I'll try and be as quick as I can, and a few things are just purely drafting things. I'll try and avoid those, but one of the things is, so 4.103, this was the, the staff version, the current version eliminated that part B about the safe harbor. And I understand that the intent is that if and when it gets passed, there will be decision made about, when it goes into effect and, when the old ones sunset. I understand there's also discussion of having that be 2 years instead of, 4 or 5 years. The one point I want to make here is that one of the things that got eliminated from when you eliminated B was a very clear provision that schools who comply with the new rules do not also have to comply with the old rules and guidelines. And I think that's very, very important, because otherwise we're going to have to comply with 2 sets of rules and guidelines. And so, if it's crystal clear that that's going to be addressed if and when it gets passed, I guess it's not the end of the world, but that's really got to be addressed somewhere, because that is critical. Otherwise, we're just layering on more requirements and sometimes contradictory requirements onto pre-existing requirements, right? Because whenever these rules get passed, the old rules necessarily go away, but the guidelines don't, right? And if a school has to comply with the new rules that get adopted, but the old guidelines, which is where most of the pre-existing substantive, regulations exist, it's going to be a total mess and really undermine what we've been trying to do. So I think
it is our plan to have guidelines ready for when the new rules take effect. In advance of that, I would hope, and also to address the phase-in with any new requirements in guidelines. I think that's what we're planning on recommending to the full committee.
Okay.
As far as I lost my train of thought. Go on.
Sorry, I didn't mean to.
No, I derailed myself there.
So the second thing is, I know I brought this up at the meeting with the 4 of us, but I want to make one more pitch for it. I know the current version of 4.147, which addresses the jointly accredited status, the current version added a number of provisions that jointly accredited schools need to strictly comply with. And I want to make one more push to try and reconsider that, at least in part, because as I read it right now, according to my count, there's 40 different numbered provisions in 4.160 that schools have to comply with, and jointly accredited schools have to comply with 31 of them. And it's not just a numerical thing, right? It's that, when Greg Brandis and I tried to come up with the initial language of this, we really try to think very carefully about what are the things that are really unique to a law school, right? Because if we're assuming a jointly accredited school by definition is also accredited by a regional accreditor, what are the general things about assessment, about transparency, about, student services and, things like that? What are the things that we can safely assume are going to be in those things, but what things are really specific to a law school? And my concern is that the current version requires jointly accredited schools to be subject to a number of provisions that wouldn't necessarily be, unique to a law school, and therefore, it's not really getting them much. It's not really getting the state bar staff much in terms of things they no longer have to monitor for those schools. And some examples, the staff version, it now requires schools to be subject to all of 4.160B and all of 1.460C, which deals with diversity inclusion. And, again, while I don't think those are bad things, I am concerned that it may end up undermining what the initial reason for having this separate jointly accredited status was. And if you look at 4.160B, there are, I think, 18 or 19 different provisions in them. Some of them, I don't know that a jointly accredited school would need to comply with. Statement of program learning outcomes, course learning outcomes. Pretty much every accreditor requires assessment. Clearly, provisions 6, 7, and 8, which deal with particular rules about admissions and prior law study and transfer credit from students who had or hadn't passed the FYLSE. That I could see everyone having to comply with. But 10, assessment of student learning, 11, grading, quantitative academic requirements. Again, I think 12 would be worth having, but 13, 14, 15, faculty development, evaluation of faculty, academic freedom. These are really general things that, by having them all in there, I think really just detracts from what it even means to have a jointly accredited status. So I wanted to make that pitch. Let's see here. 4.160A10 regarding compensation not being based on number of students. This is on page, I guess, 12 of the current draft. So, one thing that occurred to me, I know we have this parenthetical about other than compensation paid to a student or associate for reading and correcting assignments, tutoring, or similar activity. One thing that I don't know that it does address is, I think, a very common scheme for payment of part-time faculty, which is that they may get paid a flat fee if there's, say, between 10 and 50 students, but they may get paid less if there's fewer than 10 or more if there's more than 50. And it's not clear that this provision prohibits that. I mean, I don't think it was intended to, because it's a legitimate and commonplace compensation structure, but it arguably might. And so I don't know if the committee would want to consider going back to the original language proposed by CSBARS, which prohibited compensation based on number of students who apply, enroll, whatever, if they're involved in advertising, marketing, admissions, basically trying to eliminate the mercenary incentive, right? So I just wanted to put that out there for the consideration. And then on 4.160B11, I think there's just a mistake or a drafting thing, because B11, this is on page 15, the last sentence, which was supposed to be the policy on pass-fail grading, I think it was just an insert that never actually got drafted. It just says policy on pass-fail grading and excluding such grading in bar-tested subjects. So I think that's what that meant, but I wasn't clear. I have 3 other things. 4.160B12D. So I'll be honest, I don't love the 12.5%, but I understand it's at least more than what we had before, right? If it was 10%. I will say, though, that this is actually under D3. So if the number is going to be 12.5% based on an assumption of at least 80 semester credit hours, and that comes to 10 credit hours for clinic or externship. Okay, but if that's the case, then I think that 40% in any given academic year still needs to be raised to 50%. Because if you've got, let's say, 8 semesters, 4 years of a part-time program, right? You've got 10 credits per semester or 20 credits per year. And if you can have 10 credits, but you can't have, if you can only have 40% of a 20 credit year, you can only have 8 credits in a given year, which what if a school wants to have a student take 5 credits in the fall and 5 credits in the spring? Under this rule as drafted, they couldn't do that, because even though that'd be within the 12.5%, it'd be more than 40% of the 20 credits in that academic year. So I think for consistency, that has to be 50%. Okay, 2 other things. One is I appreciate the intent to bring back the possibility of a school requesting a hearing when there's probation. My question is the way it's been reinserted into 4.170. So if you look at 4.170B, and it's entirely possible I'm not reading it correctly, but under 4.170B, it says within 15 days of receiving a notice of noncompliance, right? And then it goes on towards the end and it says, and the law school may also request a hearing pursuant to 4.175. And then, but it's after that point under B3 that the committee can provide a written notice of sanctions, right? So does this mean that as soon as you get a notice of noncompliance, you can request a hearing even before you know what the sanctions are going to be? Is that the intent?
Yes. The idea is it's not meant to be, the hearing is not meant to come after the full committee has basically decided the matter. But it provides the option for the school to request a hearing before there's any full decision. So it's not see what you get, and then if you don't like it, you ask for a hearing to try to change the result. I see it more as a time management issue for the committee. If you, the law school, want to put on a lot of evidence or take a lot of time in making your case, you're going to find that there are practical and just institutional difficulties doing that before the full committee, and therefore you'd be best served by convening a hearing panel, which would then make a recommendation, which would go to the full committee along with the record that was developed at the hearing. So that's what I was trying to achieve there. Okay,
thank you. My last point then, under 4.173 B, which is on pages 23 and 24, right? So in terms of the timing of when the committee can terminate accreditation or provisional accreditation, it says this date should generally coincide with the end of the current semester, though the committee may terminate accreditation immediately in its discretion. So the way this reads, if I understand it, the committee has discretion to terminate sooner than the end of the current semester, but not later than the end of the current semester. And I think that's really problematic. I mean, I would make it longer anyway, but again, what if accreditation gets revoked 3 weeks before the end of the current semester? As it reads, the committee would have no discretion to say, okay, you've got one more semester to wind things down. And regardless of whether we don't, whether you want schools to have that extra time, it's really important for students, because there's no way the students could make alternative arrangements, even with the school trying to facilitate it in that short of time. So I really urge the committee to reconsider, if you want to make end of the current term the default, but give the committee discretion to go longer than that, at least that would be one thing. But as it stands, I think it's really setting up students for failure.
Okay, I think I guess allows it, but I could see making it a little more clear so that you don't have that anxiety about it.
Okay. The rest are, substantive things which I disagree on, and I guess, so you win some, you lose some, but those were things where I thought the committee would really want to know about, or that there was really uncertainty about what was in the language. So I thank you for that. I might have a couple of other drafting things I'll email Natalie about, but I appreciate consideration for that.
Okay, yeah, and the sooner you can share those, the better. For instance, late today would.
I will, yeah.
We can think about them tomorrow, maybe.
Thank you, Marty. Anyone else on the committee want to speak to the rules? Brian.
Yeah, first I want to officially introduce myself to Mr. Kramer. Nice to meet you. I think we met once, it seems like many years ago already. I've only been on this committee a year, but it seems like we met at some point, but it's been a lot of time since then. And I want to thank everybody, especially Deans Gardina and Pritikin, Mr. Kramer, and Mr. Cow, for the work they did since last August. I think that was important for all of you to be doing that. I just want to confirm that I did send in some written recommendations and suggestions after our August 20th meeting. I sent those in writing on August 20th. And I do understand, Mr. Kramer, that you did have a chance to review those when you were working on these this last couple of months. Is that correct?
Yeah, I think I saw them in the last few days.
Okay. So I don't want to repeat things. I do want to concur with Dean Pritikin on the issue of termination. I think it's crucial to protect our students, to give them some time. And as he said, even if we as a school are trying to be prepared for such things and we see it coming and we try to facilitate changes for our students if need be, we don't want to punish the students. If the school can't stay in compliance, it's not necessarily evil doing. And so we want to be able to make sure that our students have a chance at least to finish out the school year they're in. And so I would really encourage language to that effect. So the CBE certainly has the discretion to look at each case individually and see what's going on. Egregious examples of non-compliance and failure to comply after repeated warnings, all of those things, I understand that the CBE should have the right to do something more immediate. But I think in the vast majority of cases, we need to make sure that the students have the protection to finish out what they're in at the least for that school year. In my written proposals or suggestions, I suggested they should be able to teach out as well, schools. And I know that's not in these rules apparently, but that, like Marty said, you win some, you lose some. So I just want to say I do appreciate this work that's gone on, and I want to make sure that the written comments that I provided at the date for the August 20th meeting are also submitted to the CBE. I asked that those be part of the August 20th meeting, but they actually ended up being circulated more as a public comment. I was doing that because, as Jackie said earlier today, we all didn't have very much time at the August meeting to have gone over what we were even reviewing during that meeting. So that's why we were encouraged to send in written comments, which I did. And so I would ask that those be part of the package that is submitted to the CBE when they're making these decisions. Thank you.
Thank you, Brian. Any other members of the committee? Have Greg Brandis.
I just have a couple of things in addition to what has been raised previously. I had a question about Rule 4.147, the newly titled Jointly Accredited Rule. I'm probably missing this, but in the previous versions, was there not a provision that explicitly stated that those schools were not subject to the remainder of the rules, with the exception of core requirements? And that provision doesn't seem to be anywhere here. So the definition doesn't include it, and 4.147 doesn't include it. So what's the intent there? It would seem necessary to say that.
Let me find where it is said elsewhere.
Is it? Okay.
Let me. If you look in 4.172B as in boy, we're talking about probation. It refers to our ability to basically revoke the jointly accredited status if we find you're out of compliance with a core requirement. And then also in 170 it refers to a jointly accredited law school not in compliance with any core requirement again. So those are like the triggering tests for discipline.
Okay, so the follow-up is that there is it intended that the schools would not have to comply with the non-core requirements?
Yeah, I think so, on the assumption that they're being met through other means, being the requirements of the jointly accrediting agency. Although I'll let you know, I am going to point out to just as in my highlights reel summary of what these rules do to the full committee, point out to them that there will no longer be periodic inspections of these schools, and that we can only discipline with regard to the core requirements. So I will make that clear, and I'm hoping that doesn't come as a surprise to many of them, but I think it might, because they really have to read these things in their totality and stroke your chin a little bit to maybe for that to hit you in the face. I know it took me a while.
Okay, well, we'll see. I guess they'll have to see if everybody understands that accurately as we go forward with them. The only other thing that that was really the only substantive thing. I do have a couple of kind of odd quirk draft things. One is 4.105B, council approved law schools, that definition contains quoted language for sort of the definitional item. And that quoted language is not reused later. It's varied in 2 or 3 different ways when this is referred to. So could I make the suggestion in 4.120, 4.121, 4.141, all of those should be conformed so that they use the same definitional language for referring to schools with council approval. Just because of the way it was structured in 4.105, the definition is a whole phrase that's quoted. And so you have to use that exact phrase later, otherwise you're not using the definition. If it was something shorter, it would be more flexible than it is the way it's put together. But I found it a little confusing. Also, was it that it required a council action to approve within the last 12 months, or just that the institution had been approved by the council at some point within the last 12 months. And in one place it does say it that way, which I kind of latched onto as assuming that was the intent of all of them. But it would be useful to be sure that they all say essentially that, so that if that's indeed the intent, so that it's very clear. Because in one spot it really sounds as though, I forget which one, I think it's 4.120 and 4.141, which repeats the same language or close to it, that there has to have been like an approval action by the council in the last 12 months. That's what it almost suggests, the way it sounded to me. So just to disambiguate that a little bit in those different sections. So 4.105B, 4.120, 4.121, and 4.141 are all the sections where I noted that issue. There might be others, but those are the ones I wrote down.
Okay, noted. The point of that was to say that if you fall out of ABA's orbit, you can go directly to provisionally or fully accredited. You don't have to go through registered status with us.
Yeah, and I think that intent is fine, and I have no concern about it. I just want to make sure that when you're reading the rule, it's clear enough.
Yeah, we'll take another look.
Yeah, and I think, Jackie, that was it. Just a point of clarification: Are we voting on a recommendation on these, Jackie, or it's not an action item?
No, we voted on the CSBARS version.
Yeah. Okay.
And that was the only recommendation we were making. So this was brought to us for comment and consideration, but no action on our part.
Okay. Thank you. That's just checking. And that's it. That's all I have. Thank you.
So I again appreciate, I think, Paul, you could see the benefit of hearing from all members of CSBARS, while Marty and I think did our best. The more eyes, the more perspectives, the better the comments and the richer and deeper the discussion. So I appreciate you being here. I'm glad that Michael was able to be here as well and listen to all the members' perspective on the rules that are being presented to the CBE. I really encourage members of the public who are invested in what these rules look like, take the time to send Natalie comments before Friday's meeting if possible. Certainly, as Paul mentioned at the beginning of this meeting, if you want to speak publicly to the CBE, those comments are going to be taken immediately at the beginning of the CBE meeting and not before the Ed Standards. So it's important that you be a part of the CBE at the 9 o'clock start. I believe it's a 9 a.m. start. Is that correct, Natalie? I think that's correct. But be there at the beginning to provide your public comment. But as I understand it, Paul, except perhaps some drafting changes that might occur as a result of things that changed out, the substance of the rules are being presented to the CBE as they've been presented to us.
Yes.
Okay, thank you. I do know that we still have some staff reports, and I also know that I didn't open it up for public comment generally. So I do, I'm sorry, Paul, oh, Paul's leaving. Thank you so much, Paul. On to your next SBAR
Right.
responsibilities. So
Okay, and thank you all for your input.
Thank you, Paul.
Wanted to return to the staff reports, but first I did want to open it up for public comment. I wanted to limit that public comment to 2 minutes. So if anyone has a public comment that they'd like to bring to CSBARS, I encourage you to raise your hand now, and Grant will unmute you.
Michael Cow.
Hi, this is Michael. I just wanted to take the opportunity to thank everyone so that we could learn a lot from the entire committee of CSBARS. Paul and I really appreciate, Natalie as well, the input that we had with meeting with Jackie and Marty as a group of 4, and then definitely with this meeting. So really wanted to appreciate how valuable your input was. Thank you so much.
Thank you, Michael. All right. I'm not seeing any additional public comment at this point, so I want to go ahead and pivot back to the agenda with the staff reports on the very important bar examination that we just had. Yes, Natalie. Oh, Kareem.
We do have
Sorry.
Kareem, yeah.
Yeah.
Kareem, if you want to.
Yeah, am I on now?
Yeah, you are.
I just want to say good afternoon to everyone. It's been a fun time deliberating and creating and doing all the fun work we've done on CSBARS. I'm happy to see us making significant progress, and I'm thankful for each of you, the relationship that we developed. And just want to give a real big shout out to staff for their continuous support. What we undertook was not easy, and I know we still have to take this into Friday. But definitely looking forward to additional comments and any kind of dialogue to ensure we get something that works for everyone. So wishing you all the best, and just thank you for all of your work and your commitment, because I know it's not as told as often, but a lot of you are spending precious time developing this, and it's for a greater good. So thank you for all your work.
Thank you, Kareem. All right, now not seeing any additional public comment. I welcome the continuation of the staff report, starting with the bar exam.
Hi, everyone. Thank you, first of all, the deans. I know a lot of you received many emails from me during the, I don't even know how many weeks it was altogether once we moved it to October, but I really appreciate all of the partnership we have with the deans. I know many of you hosted applicants at your schools and were in communication with me, and it was really, I really appreciated it, because so many things that we were doing were of course brand new, and if something we had written didn't land well in terms of its clarity and you were able to tell me, I just really can't express to you how much I really appreciated you shooting me an email, letting me know, so we could correct things in real time. So thank you. And we already have the application for the February exam. It's been open since October 1st. So, we're going to learn a lot from this past experience. But the bar exam was October 5th and 6th of last week. And just to share some numbers with you, so altogether, we had 9,762 takers of the exam. 9,632 of those were using Exemplify. So of that number, 138 were on-site testing accommodation students. So they didn't have the remote proctoring, they were being live proctored. But the rest were all using the remote proctoring. So we had people at 6 different hotel sites, but so 138 of them were those on-site TA, and then 151 we had non-accommodated students who had extenuating circumstances. So we were trying to be very inclusive when we sent out the testing conditions to see if people didn't have good Wi-Fi or didn't have a quiet space to test. And so that was very different for our on-site procedures. So we had 6 in-person sites. There was a hotel in Sacramento. That's where Natalie was. And we had 1 Burlingame and San Diego, and then 3 in the kind of LA area. So we had 6 hotels where we had those very different kind of in-person procedures. We also had COVID safety protocols that were reviewed by public health individuals and epidemiologists. We had COVID safety leaders, and that was what Natalie's job was. She was making sure people were masked up and staying 6 feet apart. We took temperature. So it was a whole very different, not just because the bulk of applicants were remote, but even our on-site procedures were just so different. And it was a real testament to the staff for rolling with all the changes, and really to the applicants too, because there were some patience about, you know, if you're standing in a line 6 feet apart getting your temperature checked, that might go a little more slowly than when you were coming to one of our big exam sites. So, so it was very different. I think I might have not given, I did give you the total. So the 9,762 was a total, but we did also have, so out of those people who were remote proctored, that was 9,632, and then we had 110 non-accommodated students who were handwriting, and 29 accommodated students who were handwriting. So yeah, that was our total after all the different kinds of rounds where people were withdrawing with full refunds, or maybe they didn't do the 2 mock exams, so we had to withdraw them administratively and they couldn't sit the exam. I was sending out some messages to the deans during Monday and Tuesday, just what we were hearing back from ExamSoft. So we had, the administrators were in these Zoom rooms with ExamSoft. I don't even know how many hours. It started at 6 a.m. our time, and I went probably to 6 p.m. our time. So 12 hours for those days. And it was good in the sense that we could real-time troubleshoot. So when people called into our call center, I could talk to ExamSoft about troubleshooting some things. But as I sent you, overall, they were reporting that 98% of national applicants for all the different bar exams were starting on time and getting into the exam. And for those 2% who were having issues, we were able to give more time, so adjust the time where they could get in and make sure that they could get there into each exam session. At one point, they were saying the highest, and this was only on Monday, but the longest wait time they were having was 15 minutes, which is, that probably feels like an eternity to the person waiting on the line. So that was when we adjusted the time for people to get into the sessions. We made it 15 minutes beyond what we would usually do to try to accommodate everyone who was waiting on hold. We had the passwords being sent out in a variety of different ways. And we had our standard landing page with ExamSoft. We had them on an admissions page. We were emailing them. And then ExamSoft had a backup page. So there were lots of different ways to find those passwords the day of. And so largely, and I know if any people who were, the person who might have been having trouble or who couldn't get in, whose laptop crashed or whatever case might have been on either Monday or Tuesday, it probably didn't feel like a success. But overall, for me, holding my breath for a long time, I think it went overall very well. But of course, please ask me questions, or now's the time too for feedback, because we are buckling up to do this again pretty soon.
Thank you, Audrey. And I really appreciated the way that the State Bar kept the deans informed, not just during the 2 days of the exam. And believe me, I think we were all getting informed from multiple sources during those 2 days, but leading up to it, because I think getting the emails that you were sending the applicants was such a help when our graduates reached out to us with questions or confusion. At least we had the emails to which they were referring. So I want to commend that part of the process, because and really just the State Bar's ability to create this remote proctoring, it's not ideal. There was no way to make this an ideal situation. And I know that the State Bar staff worked incredibly hard to make a licensing exam possible this year under not just less than ideal circumstances for the bar applicants, but for all of the staff that were working to make it happen. So thank you for making it happen. And I don't know if there's any comments or questions from the committee.
I'd like
Ryan and then Greg.
Thank you so much for all those emails. I really appreciated being kept in the loop too about the students and what was going on. Couple of quick things. Did you have any sense of how many or what percentage of red flag triggers the automatic or the remote proctoring session picked up? And if so, what kinds of things are they finding, and what should we be thinking about in case any of our students get some sort of notice? And the other thing was, I had a student ask me to pass on to the state bar. I've already talked to Natalie quickly about this, but I thought I'd tell you too. A suggestion that the MBE scores be released right away, even so that people can decide whether they need to really focus on that for February exams, since the rest of the results aren't coming out until January. Apparently, many of my students at least think there's a whole different way of preparing for that and getting ready for that test. And so they'd like to know now if they didn't pass that part of it. So those are my two questions.
Thank you. Brian.
The flags, oh, should I respond? That's fine. Okay, so for the flags, I'm sure at some point it was in the FAQs how it was going to work, because the AI is kind of doing the first round, and then on the ExamSoft side, they send it out to the human proctors to actually review the flags, and after 2 rounds there, it'll come back to us. So we actually don't have those videos back and won't have them back. At the earliest we'll get them back probably late next week, if not the week after, because it's a pretty intensive review on their side. So I'm not sure yet what percentage of flagging, or I do know, because we had our own experience with the baby bar, we asked for a lot of things not to be, obviously to kind of tone it down in terms of how many things were coming back as flags that weren't flags, like playing with the hair and, those kinds of things that are, maybe someone is moving their arms in a way that is not completely still, but it doesn't mean that it's any kind of suspicion of cheating. So very hopeful that it will be much smaller percentage of actual suspicious flags that come back to us, but I don't know yet. And then, yes, Natalie and I got your suggestion. We sent it to the grading team. Did you just email it yesterday? It was either yesterday or the day before about the MBE, or I can't remember.
I don't know. All the days are rolling together up here. I don't know. They really are, and they have been for a year. I can't separate them.
Yeah, at least since the pandemic. But yes, we did send it to the grading team once we got that from you.
Okay, great, thank you.
Thank you, Brian. And I think Greg Murphy?
Yes, just a comment. I know that the deans and the staff must have felt like they've been at war for the last several months, and no battle plan survives the first shot of a war. One of the casualties here may likely be the reliability of the exam scores as compared to other exams. I know there's been alteration with the MBE. I used to be on the inside of all that, but I'm not anymore. But the MBE had a reliability coefficient of 0.92 or better. I'd be surprised if you're able to achieve that. That has real world consequences. And I'm not going to bore you here, but I would urge the deans and the staff to really pay attention to that, so that nothing could be done in the sense that, Supreme Court rules and the bar, and you got to make changes because of COVID. So I'm not offering criticism here. I'm only suggesting that everybody should pay attention to that, because reliability is important to the fairness of the exam for the entire examination population.
Thank you, Greg. And then Marty, did you want to speak? I thought. No.
I did. I just wanted to add a comment. I also wanted to echo the thanks and congratulations to everyone on the State Bar who made this happen. And I just wanted to put it in perspective for a minute. If you guys remember, back in March, April, whenever this thing first started happening, there was a white paper that was put out by a group of very well-respected people within Legal Academy, laying out what the potential options were for dealing with the bar exam in the time of COVID. And a remote bar exam was basically just immediately dismissed by them as, well, this could obviously never happen, so let's not even talk about it. And 6 months later, not only was it a reality, but they administered it in one of their largest cohorts ever. 10,000 people taking an exam remotely just in California alone. It's really unbelievable. It's a monumental task. And as Audrey correctly pointed out, for those 1 or 2% of people who things didn't go perfectly smooth, I'm sure, they would describe it as an unmitigated disaster. Most of them got it worked out, but there are a lot of people out there saying anything short of perfection is failure. And that's obviously just not a fair standard for any administrative effort, but particularly one of this magnitude. I think it's just incredible that they pulled it off at such a high level of success. So I just wanted to give you my kudos for that.
Greg Randis?
Yeah, and Marty stole most of my thunder, Audrey. I wrote you already my thanks for the incredible communication, really, I think that the bar undertook this time. I hope that you'll always undertake that level of communication with the applicants. I know it's a burden and a bother, but I think in this particular situation in particular, it made it a lot easier for an awful lot of folks. I've also shared with folks at the bar the feedback we received from our graduates who took it, and the words I got were things like flawless, seamless. I mean, this was not in any fashion troublesome to the graduates that we had go and take the exam. And I don't know, Marty, what your graduates are like had to say about it, but ours were extremely positive about everything the State Bar did, about how ExamSoft worked, about all the opportunities they had to get it all right, figure it all out ahead of time. Again, I echo a lot of what Marty had to say about how well it worked under the difficult circumstances of the administration of it. I did have one quick question about it, which was whether or not the percentage of folks who no-showed was substantially higher or about the same as it would typically be on an exam. Now, I'm not talking about, because I know 12,000 people registered, but I mean the people who sort of just didn't show up on the day. I wonder if you had any idea about that comparison point for this exam compared to other exams.
That's actually that's a statistic that I didn't have to share yet today. And I think so the grading team needs to get all the answer files back, and then we were compared to that number that I gave you about how many people were supposed to be active in ExamSoft. And so I don't actually know the percentage of no-shows yet, but I think that will be an important metric to see if it's consistent with all the other administrations, higher, lower. Like I hope to be able to share that with you all soon.
Yeah, one of the things that I have said to folks is, there's a percentage of people who are planning to go to the test center and don't get there. The alarm doesn't go off, or they get stuck in traffic. They catch a train, stuck in a train, and the doors are locked by the time they get there. That's a sizable percentage of every exam. And so folks need to factor that in when you're considering the folks who weren't able to make this work, that some of those folks wouldn't have been able to make it work either for a variety of reasons, even if they had been able to go to a test center. So.
Yeah, for sure. Well, and I started at the State Bar in February of this year, so I went to the February bar exam, and I remember someone, because the typical administration, you get like 3 essays at once, and as soon as he looked at it, he just walked out and said, never mind, So that happened.
Yeah,
Things like that happen.
Do you have an idea of how many of the percentage that finished? So we called them takers, 9762 takers. You probably don't know that, how many actually completed the exam.
No, it ended up being like 8 separate files, right? Because we had all those, every essay was a different session. That's why they had so many breaks. And so we have to see how many actually uploaded all 8 of those. And then that'll be, then we'll know how many. And we can look at that too. I mean, all the data should be there in ExamSoft. We just have to kind of sort through it to see, well, maybe so many started at essay 1 and by the end they just kind of stopped going. So, and then I'm not sure yet. I don't know.
Well, I'll be interested to hear about those in future meetings whenever you get a chance to.
Hey, I can send you an email once I know. I can email all these more numbers once I know, for sure.
That would be great. Well, it's a fascinating experiment, and again, you did all of the folks there at the bar did an amazing job with it, I think. So.
Jay.
Just really want to echo the kudos, congratulations, it went well. As everyone here knows, law students, bar examinees are very willing to complain about any perceived or actual harm to themselves. In my experience from going through this, only one had a complaint and it was resolved and they were able to complete the exam, even though they had technological issues, just because of their computer. So I think that was excellent that it did work. I think from the first year law students example, changes were made. And for this one example, they were still able to take their test. The last one is just a question. I don't know if you're allowed to answer this or not, so I'll just pre-warn on that one. Is there a staff recommendation right now for the February administration to be in the same modality? And do you think it might be in February for the administration? And I don't know if you're allowed to talk about that or not.
Like everything's going to be the way we have it in February. We have heard no other direction, right? So what we did when we opened up the February exam October 1st, we only have one option right now, which is online. So what we'll do, similar to what we did this time, except that when we opened it for the July exam, we had all the other modalities open. So, but right now it's open only as online, and when we send out the testing conditions for all the applicants to review, that's when they can say, actually, I need to handwrite, or I might have extenuating circumstances. And of course, the testing accommodations process is sort of different to that we'll have to match up later. But yeah, we're thinking that the February conditions for how we should administer an exam, it will be similar to how we are now, where the safest thing will be to have it, for the most part, except for the small populations that need to be in those hotels, to have it online.
Just one quick follow-up on that. And again, from going through this experience, as Dean Pertella said, it's hard to keep track of time now post or COVID. I know there was a lot of discussion on the NCBE being reluctant on allowing their MBE questions to be used. Has that been resolved, or is that going to be a continuing issue, do you believe, for this upcoming February administration?
Whether or not the NCBE will give the remote exam, the full exam to the remote exam, is that what you're asking? My guess would be if all the other jurisdictions are going to be in the same boat, and we are nationally in the same boat with the virus, that would make the most sense to me. But it's hard for me to say what they're going to do, but that would be what I imagine will happen. That's what I hope will happen. I'm sure that's what we all hope will happen.
Definitely. Thank you.
Thank you, Audrey. I have to believe, having arrived at the State Bar in February, that your tenure here can only get better.
It's just a great 8 months.
So we have two more pieces of the agenda that I want to make sure we get to. One is a report on the first-year law students exam, which I know for many of our registered schools especially, that's important to hear about. And then we have the Access and Inclusion Committee would like to speak with us as well. So the first-year law students exam report.
Right. So in the midst of all of this, we moved the baby bar to November 17th because it's typically in October. So the late filing deadline for the baby bar was actually yesterday. So we have, I can tell you the exact number, but I think it's 381 between pending and approved applications right now for that exam. And we're sending out today that acknowledgement and acceptance of testing conditions document. So all of the folks who are in the pending or approved bucket for the November 17th exam will have the idea of how that's going to be administered, and again, whether or not they might want to handwrite, or whether or not they have other extenuating circumstances they need to let us know about. So that's going out today. It'll be due November 2nd back to us, and the other deadlines are on the webpage in regard to that exam, but that's kind of the update. If you have any more questions about the baby bar, let me know.
Any questions among the committee? And I know, Audrey, there was some question about kind of how things were moving through the legislature on that fourth administration. Do you have any update on that?
I do, but it's going to be cue Natalie Leonard for the update on that. She's on mute. She's saying this.
Okay, the pandemic mute, sorry. So that is proceeding apace. The legislature has passed the required changes that will take effect along with the state bar bill. The Board of Trustees has passed the required changes. The committee has passed the required changes. The last step is to receive approval from the Supreme Court. I would not presume to speak for the court, but given that it was a suggestion of the court, hopefully we will hear back quickly from the schools regarding that requirement. And we understand that there are a number of people who will be taking the exam in November, for which it will be their fourth try.
Thank you, Natalie. And I want to welcome Elizabeth Holm and Crystal Bundag to our committee. So they've waited patiently through this entire committee meeting. So thank you for that. And I want to welcome you. And I think you have a PowerPoint presentation to talk with us about some of the new data collection efforts.
Sure. Thank you, Dean Gardina. Grant, are you sharing the PowerPoint?
He should be, but I can go ahead and bring that up. Just need a second.
Sorry about that. Here you go.
Oh, perfect.
you start the slideshow?
Yeah. All right.
All right. Well, good afternoon. I want to thanks the committee for having Elizabeth and I both join and speak to everyone to share some exciting updates regarding the 2020 Law School Retention Survey. As mentioned, my name is Crystal Bending. I'm a senior program analyst with the Office of Access and Inclusion. Also from the Office of Access and Inclusion is Elizabeth Hom, acting program manager. We can move on to the next slide. Great. So I'm sure you might have heard about this law school retention survey. Natalie's been gracious to include some updates in the email communications to the deans regarding this 2020 survey. In terms of the purpose, it's actually threefold, and kind of just to briefly give a high level. First and foremost, we want to learn about the existing efforts to recruit and retain diverse law students in California's law schools. That's going to be all of California's law schools. We also want to develop a resource to summarize those current efforts and highlight best practices. Both of these efforts are in support of the overarching goal to achieve a diverse statewide attorney population reflecting California's diverse population as well. Next slide. Great. I wanted to provide some details in terms of what to expect when everyone does receive the survey. So we'll be gathering information in the following areas listed below, including student recruitment efforts, details regarding academic support programs, faculty and staff. We really wanted to reach a comprehensive level in terms of different programs and efforts that the schools have. I also wanted to give a special thank you to Dean Strauss and Dean Frickberg for providing some initial feedback on the initial versions of the survey, and we've really utilized and built upon those surveys. So hopefully what you will receive will feel comprehensive and that we didn't leave any corners unturned. In terms of administration, the survey will be administered via Qualtrics, which is a survey platform. And each law school will have access to a unique survey link. We are anticipating that it will take several faculty and staff members to complete the survey because it covers so many parts. So we'll have a unique survey link that can be disseminated and shared so everyone can be updating the survey at the same time. Here's just kind of the timeline of what we're anticipating. We are in the final stages of finalizing the survey, and we'll be conducting beta testing on the Qualtrics platform. And we'll be sending out an email which is addressed to all of the deans. You'll be receiving the initial email with the link next week. We did want to be mindful of everyone's time, and given the length of the survey, we are requesting to get the responses back by the third week of November before the Thanksgiving break. Yes. If you have any questions, my contact information is up on the screen here, but I'm happy to answer any questions now if the committee has any.
Do any committee members have questions about the survey? Okay. All right. Well, yes, Greg Brandis.
Since we haven't seen the questions, I'm just wondering about is this sort of survey that's requesting data collection as we're also doing a bunch of data collection for annual reports at the moment? Or is this a survey about programs and policies and things like that? What is it about?
It's more about, we're gathering more some qualitative data just regarding the programs. We won't be asking for hard statistics, as we know that's coming in through the annual report, so there shouldn't be any duplicate efforts. So we want to ask, program specific, what efforts are you doing? Who are these programs geared towards, et cetera.
Okay, thanks.
Anyone else have any questions? All right. Well, Crystal, thank you so much for bringing this forth, and we'll all be looking for that in the next couple of weeks.
Yes, thank you so much. Thank you to the committee. Look forward to receiving everyone's responses, and we're really hoping to get really meaty information and be able to report out and kind of show what everyone's doing so everyone can get some ideas across the state.
And just, Crystal, just to point out, and I'm sure, I don't know whether this is going to happen again, but you've timed it exactly when we're doing our annual reports as well. So every faculty or staff member that might be contributing to the annual report is now going to be filling out a Qualtrics as well. So I don't know whether you've thought about changing the timing at all so that we're not trying to manage the annual report and this survey at the same time.
Yeah, thank you so much, Dean Granita, for that feedback. We actually sent out a similar survey last May, and that was kind of our target timeline, but due to the pandemic, it delayed a little bit, but we do think this survey, it will be manageable. We've gotten some good feedback from law school deans and other staff, so hopefully in the future, if we administer something similar, we will definitely be mindful of that time frame.
Thank you. Yeah, I know everyone right now is addressing, as Dean Pertil calls it, the Golden Gate Bridge that we're painting again.
Yeah.
All right.
Thank you.
That, I think, concludes all of our agenda except for recent developments. Natalie, I don't know whether there's anything within the recent developments that you'd like to add that wasn't on the agenda.
Only just to remind people that if for those in the audience that may be interested in serving on CSBARS in the future, the application period was extended through October 15th, which is tomorrow. So if you are interested, you can send an application to me with a letter of interest and a resume, and it will be shared with the Committee of Bar Examiners Chair and Vice Chair, who will be making selections shortly thereafter.
And Natalie, could we assume that those appointments would be made at the December meeting? So we might have some turnover both in the chair position as well as on the committee by the January 2021?
Because the committee makes the chair and vice chair make the appointments, it's possible that they could take effect in either December or January. We didn't ask the committee to commit to a timeline right now with everything going on with the bar exam. So we'll be finding out within the next about 14 days.
Okay, so it could be possible that CSBAR turnover could occur before our next CSBARS meeting, or at least the one thereafter.
That's correct.
Okay, thank you. All right. Okay, any other comments or questions from the committee before we seek to adjourn? Okay. Well, it was good to see everyone again, and do we have a motion to adjourn?
So moved.
So moved. All right.
We do have a raised hand in the chat, or in the, I don't know.
I see that. It's the same person who accidentally raised their hand previously, so we could certainly check in with them to see whether or not they have public comment has passed. So okay. I wasn't intending on calling on them, but I appreciate you raising that, Grant. So if there's no further comments or questions from the committee, I can go ahead and move to adjourn the meeting, and we will see you. Some of you, I hear you at the CBE meeting for public comment. All right. So adjourned.
Thanks, everyone.
Thank you.
Thank you.
Thank you.